My learned brothers and sisters, this is Advocate Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I selected a very good topic on criminal law, and the topic is abatement of suicide. Bharatiya Nyaya Sanhita 2023, Section 108. Previously, it was the Indian Penal Code, Section 306, abatement of suicide. And before talking about Section 108 of BNS, now make it very clear that every time I will not repeat Bharatiya Nyaya Sanhita. In short, it will be referred as BNS, that is Bharatiya Nyaya Sanhita. BNS Section 85 deals with husband or relative or husband of a woman subjecting her to cruelty. Section 85 reads, whoever being the husband or the relative of the husband of a woman subject with woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Now, in Indian Penal Code, cruelty was not defined. It was given in explanation to IP Section 498A. Here, in this new law, BNS, cruelty is defined. In BNS Section 86, it reads, for the purposes of Section 85, cruelty means A. Any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman. Or B. Harassment of the woman, where such harassment is with a view to causing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. BNS Section 108, abatement of suicide. If any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. What is the meaning of suicide? Spelling is SUICID. The word suicide in itself is nowhere defined in the code. SUI means self and CID means killing, thus implying an act of self-killing. A person committing suicide must commit it by himself or herself, irrespective of means employed by him achieving his object of killing himself by any means. Legal analysis. Our Honorable Supreme Court in year 2022, Supreme Court 820 and para 18 and 22 has questioned about this. Court should not proceed against relatives and in-laws of husband if no prima facie case is made out. There has to be a prima facie case. False implication by way of general omnibus allegations made in course of matrimonial dispute, if left unchecked, would result in misuse of process of law. This is a warning question from Honorable Supreme Court. Therefore, court should not proceed against the relatives and in-laws of husband when no prima facie case is made out against them. General and omnibus allegations cannot manifest in a situation where relatives of complainant's husband are forced to undergo trial. A criminal trial leading to an eventual acquittal also inflicts serious scares upon accused, and such an exercise must therefore be discarded. It affects to the prestige and social status of the accused for false complaint. What are the consequences of cruelty? Question. Consequences of cruelty which are likely to drive a woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of the woman is required to be established in order to bring home an application of BNS section 85. Previously it was 498A IPC. Now it is BNS section 85. The requirement of statute is act of cruelty by the husband of the woman or relative of the husband, and their acts can be attributed to be painful or distressing. BNS section 80 and section 85 cannot be held to be mutually inclusive. These provisions deal with two distinct offences. Cruelty is a common ingredient to both the sections 80 and 85, and that has to be proved. Under section BNS 80, it is dowry death that is punishable, and such deaths should have occurred within 7 years of marriage. This is in BNS section 80. But no such period is mentioned in BNS section 85. This is the basic difference between BNS section 80 and 85. A person charged and acquitted under BNS section 80 can be convicted under BNS section 85 without their charge being there if such a case is made out. If the case is established, there can be conviction under both the sections. Maltreatment and demand and lust for money from beginning of marriage, subjecting the deceased to torture and assault on refusal to fulfill demand of money, and not being allowed to meet or talk to her family members will amount to cruelty. This is the meaning of cruelty given by Madhya Pradesh High Court. Citation is 1997 Criminal Law Journal 1005. Now, let us understand one expression, that is soon before her death. What is the meaning of it? The term soon before is not synonymous with the term immediate after, not immediately after marriage. Suffice, however, to indicate that the expression soon before would normally imply that the interval should not be much between the concerned cruelty or harassment and the death in question. There must be existence of, this is very important, there must be existence of a proximate and live link between the effects of cruelty based on dowry demand and the concerned death. If alleged incident of cruelty is remote in time, and has become stale enough not to disturb mental equilibrium of the woman concerned, it would be of no consequence. There cannot be any punishment for this. Proximate and lining between the effect of cruelty based on dowry demand and the consequential death is required to be proved by prosecution. The demand of dowry, cruelty or harassment based upon such demand and the date of death should not be too remote in time which under the circumstances be treated as having become stale enough. This is the meaning of stale enough. The expression soon before is a relative term which is required to be considered under specific circumstances of each case, and no straitjacket formula can be laid down by fixing any time limit. A conjoint reading of BSA section 118 and BNS section 80 shows that BSA section 118 and BNS section 18 conjoint reading shows that there must be material to show that soon before her death the victim was subjected to cruelty or harassment. Prosecution has to rule out. What is the duty of the prosecution? Prosecution has to rule out the possibility of natural or accidental death so as to bring it within the purview of the death occurring otherwise than in a normal circumstances. Presumption under section 118 of BSA is a presumption of law. The presumption shall be raised when presumption can be raised under section 118. The presumption shall be raised only on proof of the following essences. The bare reading of BSA section 117 shows that to attract application of BSA section 117, it must be shown that, number one, the question before the court must be whether the accused has committed the dowry death of a woman. This is the first thing court has to see, whether the accused has committed dowry death. This means that the presumption can be raised only if the accused is being tried for the offence under section BNS section 80. Number two, the woman was subjected to cruelty or harassment by her husband or his relatives. The husband or his relatives were charged and subjected to her cruelty. Such cruelty or harassment was for or in connection with any demand for dowry. Such cruelty or harassment was soon before her death. Such suicide has been committed within a period of 7 years from the date of her marriage. If these conditions are proved, it is sufficient evidence and trial can be conducted, otherwise not. Of course, under section 118 of BSA, it is a rebuttable presumption and the onus lies on the accused against whom the presumption lies to discharge it. It is true that the prosecution has to establish that there must be nexus between the cruelty and the suicide, and the cruelty meted out must have induced the victim to commit suicide. On the contrary, the law requires the prosecution to establish first by cogent evidence that the death in the case occurred within 7 years of the marriage. Our Parliament has chosen to sound a note of caution. There are two. Firstly, the presumption is not mandatory. It is only permissive, as the employment of expression may presume suggests. May presume words are there. Secondly, the existence and availability of the above said three circumstances shall not, like a formula, enable the presumption may be drawn. The court shall have to have regard to all the other circumstances of the case. Court has to consider all the other circumstances of the case. The expression the other circumstances of the case used in BSA section 117 needs to reach a cause and effect relationship between whom? cause and effect relationship between the cruelty and suicide for the purpose of raising presumption. Last but not least, the presumption is not an irrebuttable one. In spite of presumption having been raised, the evidence abuse and defense or the facts and circumstances otherwise available on record may destroy the presumption. Now this may presume is defined in BSA section 2 in bracket 1 in bracket H. Previously it was defined in section 4 of Indian Evidence Act. I read out BSA section 2 in bracket 1 in bracket H. This is definition. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved or may call for proof of it. This is the definition of may presume. From the above, it is clear that certain conditions precedent by way of proved facts should be brought on record before the court can draw a presumption under section 117 of BSA or section 118 of BSA. There are two sections, BSA 117 and 118. I'll read out. These are the conditions. From the above, whatever we have discussed so far, it is clear that certain conditions precedent by way of proved facts should be brought on record before the court can draw a presumption under BSA section 117 or BSA section 118. Defense lawyer has to take care of this. Now, our research certain citations for acquittal. A few citations are there for acquittal. When acquittal can be achieved, and this is especially for defense lawyer. Number one, there are about 10, so read carefully. Where there were no evidence to suggest that soon before the occurrence, the disease was subjected to torture and harassment, the ingredients under section 80 of BNS is not established. So acquittal. Number two, mere misunderstanding between the accused and the disease would not automatically lead to the conclusion that the accused has committed the offense under BNS section 80. The law does not raise any such presumption, so acquittal. Citation number 2006 CRLIJ 3290 SC, Supreme Court. It could not be sufficient ground to hold the two sister-in-laws liable so far as allegations against the two accused was concerned. It was omnibus in nature and had been made without any specific instance only to involve their entire family. The sister-in-laws were acquitted of the charge. Citation is 2004 to the Law General 1765 Supreme Court, where evidence on record stated that disease might have committed suicide within 2.5 months of her marriage, as she was unable to adjust herself in the changed surroundings of her matrimonial home. Being a highly emotional person, she was highly emotional. There being no evidence to suggest that she was subjected to cruelty or harassment in connection with any demand for dowry. The husband and her parents were acquitted under section 80 of BNS. Citation is year 2003 SC 992. Acquittal of accused was proper, where prosecution failed to establish that dowry was demanded prior to marriage and same was accepted. If you have demanded prior to marriage and it is accepted by the opposite party, then acquittal. No offense is committed. I'll read out again. Acquittal of accusers proper. The prosecution failed to establish that dowry was demanded prior to marriage and same was accepted. Benefit of doubt. When can be given? The appellants allegedly committed murder of disease for non-fulfillment of dowry demands. This is allegation. Prosecution case is doubtful. Adverse inference can be drawn against prosecution for not being stationary on record. In such cases, such grave cases, stationary by the police has to be on record. FIR was sent to CJM, Chief Judicial Magistrate, up to 3 days of institution of case. So delay was there, and there can be fabrication. The same created serious doubts about the prosecution case. It was not fully established that appellant was in his home when occurrence took place. There are no material record to show that appellant had intention to cure the disease. So, benefit of doubt was given to the appellant. Citation 2009 Criminal Law Journal, NOC 1124, Jharkhand. Other one is 2009 in bracket 2 AIR Jharkhand R919 Division Bench 7. Where except for certain bold statements made by prosecution witnesses that the victim was subjected to cruelty and harassment prior to her death, there was no evidence to prove that the victim committed suicide on account of cruelty and harassment. The accused would be acquitted by giving benefit of doubt. Citation is in bracket 2010, citation complete, 9 Supreme Court cases, 73. 8. When there is no other evidence, mother and brother of the disease turning hostile, and the conviction is sought to be based on dying declaration alone. There is a dying declaration. Other witnesses were hostile. Then it will be unsafe to record a conviction. The defense lawyer should find out this. Unsafe to record a conviction in the absence of the certificate of doctor that the disease was in a fit condition to make the statement. When doctor issues a certificate, on the top of it, he has to write that disease was in a fit condition to make the statement. Conscious also should be written, conscious and fit to make the statement. Next, the doctor treating the patient says certified on the dying declaration that the patient was conscious and in a fit condition to make a statement. This is very important. A true copy of the dying declaration shall be forthwith filed with the magistrate, and a record of acknowledgement shall be maintained in case papers. Next. Motive. This is just for knowledge. Motive for a murder may or may not be, but in dowry deaths it is inherent, and hence what is required of the court to examine is as to who translated it into action. As motive for, it is not individual but of family. This is to be taken in mind. An accused charged alone under section 302. The court has charged only at least 302 of IPC. Now we are at section 103 for murder. Cannot be convicted under section BNS 80 in the absence of charge framed against him, because charges for only 103, so he cannot be punished under section BNS section 80. Citation is 2001 Criminal Law Journal 2704 Karnataka. Last. No demand of dowry before, during or after wedding, marriage. by mother-in-law. So, no conviction for mother-in-law. Hope you have enjoyed this video. There's some vital information. I've tried my best to give you the very good information. If you are new to our video, please subscribe it. If you are not new and regular our viewer, then enjoy it, share it, like it, and thank you very much for joining us and patient hearing. See you again in the next video in the next week. Thank you, thank you, thank you.